Hello, everybody. Good evening from me as well. My name is Elsa Stamatopoulou. I'm the director of the Indigenous Peoples' Rights Program at the Institute for the Study of Human Rights at Columbia. And I welcome you all to this commemorative event for Indigenous Peoples' Day. I want to start today by acknowledging that Columbia's campus is located on unceded territories of the Lenape people. I acknowledge the horrific history of genocide and forced removal from this territory. And I want to honor and respect the diverse Indigenous peoples still connected to this land. As members of Columbia's community, and especially because we were geographically dispersed due to the pandemic, but also because we have lived in various other areas in this country, we can acknowledge that many of us occupy or have occupied unceded lands of other Indigenous peoples as well. We can recognize also the interconnectedness among Native American nations historically and contemporarily, and that Native connections to land are complex and can change over time while remaining strong and vital. I would like to thank the many co-sponsors of this Indigenous Peoples' Day event, in addition, of course, to our Institute for the Study of Human Rights, 9 entities from Columbia and 1 from the New York University. We have the Center for the Study of Ethnicity and Race, Columbia Society of International Law, Human Rights Institute of Columbia Law School, Institute for Comparative Literature and Society, the Institute of Latin American Studies, Mailman School of Public Health, the University Seminar on Indigenous Studies, the University Seminar on Latin America on Columbia's side, and from New York University, we have the Center for Latin American and Caribbean Studies. I would like also to give special thanks to Pamela Kaya of New York University, to Peter Wynn of the University Seminar on Latin America, and Teresa Zapeta of the Foro Internacional de Mujeres Indígenas for their help regarding this event. The panel today is a way to commemorate Indigenous Day, People's Day at Columbia this year. And we are glad that this is the second year that Columbia University formally marks the second Monday of October as Indigenous Peoples' Day. And yesterday there were several events organized by the Native American Council and Multicultural Affairs at Columbia University. Efforts to rename Columbus Day go back to 1977, when the historic Conference of Indigenous Peoples of the Western Hemisphere was held at the UN in Geneva. Indigenous leaders had gathered at that point for the International Conference Against Racial Discrimination. The conference recommended to replace Columbus Day and to mark Indigenous Peoples' Day to express international solidarity with the Indigenous peoples of the Americas. Observing Indigenous Peoples' Day is an important step in dismantling the doctrine of discovery that has plagued the United States and other legal systems. The observation of Indigenous Peoples' Day also contributes to the broader education of society, which has to grapple with its past in order to build a more just future. On Indigenous Peoples' Day, we honor and celebrate the cultural heritage, struggles, contributions, and continuing presence of the Indigenous peoples in whose lands we reside. Let me add that International Day of the World's Indigenous Peoples is marked annually on the 9th of August. The date was selected to honor the 9th of August, 1982, the first day of the very first human rights body established to deal with Indigenous people's rights, namely the UN Working Group on Indigenous Populations. This working group worked tirelessly with Indigenous peoples over the decades to build the foundations of the UN Declaration on the Rights of Indigenous Peoples that was adopted in 2007. Coming now to the topic of today. The topic is very broad. We should clarify that here we are speaking about the role of conventional state courts and not about Indigenous peoples' traditional justice systems, which is another broad area of law and practice. In fact, it has been pointed out by studies that about 90% of cases of Indigenous persons are dealt with by traditional Indigenous justice. But this should become a seminar another seminar one day. The judiciary is one of the cornerstones of democracy. Constitutions and fundamental national laws are expected to provide guarantees for the independence of the judiciary as crucial for the rule of law. Justice requires that everyone should be entitled to a fair and public hearing by a competent, independent, and impartial tribunal in accordance with the principles proclaimed in the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. About 40 years ago, in 1985, the UN General Assembly also adopted the basic principles on the independence of the judiciary. So important is the role of the judiciary that the various functions around it, in addition to that of judges themselves, have also become a central focus of international attention and international standards. More specifically, in 1990, the basic principles on the role of lawyers were adopted. And the same year, also the guidelines on the role of prosecutors. All these instruments are aimed at protecting the independence of the legal profession, of those working in the court system, because through that, the person accessing justice can expect due process and a fair trial. We should also note that the UN Human Rights Council has established a specific monitoring mechanism, the Special Rapporteur on the Independence of Judges and Lawyers, to monitor the rights of judges, prosecutors, and lawyers who are subject to attacks and violations, including threats, intimidation, external interference in conducting their professional activities, arbitrary detention, prosecution, and killings. Now, when it comes to Indigenous peoples and their rights, we can decipher two broad categories on the role of courts. One is cases brought to courts by Indigenous peoples or persons themselves. Indigenous peoples as collectivities or as individuals appeal to national courts to seek justice regarding protection of land and resource rights, matters linked to their right to self-determination or their cultural rights. Indigenous peoples have also used international human rights courts, in particular the Inter-American Court of Human Rights and the African Court on Human and People's Rights, with considerable successes. And they have also actively used semi-judicial international human rights bodies, in particular, international human rights treaty bodies, especially the Human Rights Committee on the International Covenant on Civil and Political Rights, and the Committee Against Racial Discrimination under the Convention on Elimination of Racial Discrimination, with considerable success as well. Now, the second broad category of cases is when the state and corporations bring cases to courts against Indigenous peoples. In a crisis that is indicative of our times, Indigenous land and environmental rights defenders are increasingly criminalized by states and corporations to maintain privileges on Indigenous people's land or discredit Indigenous rights and environmental rights defenders. The crisis is indicative of our times, I say, because today's major challenge for Indigenous people's well-being and even existence is the unsustainable hunger of the world's dominant development paradigm for still unexplored natural resources, which are now found on so-called remote areas, namely ancestral lands of Indigenous peoples. Wealthy and politically influential corporations tend to vilify and criminalize individuals struggling to defend environmental and land rights in areas where these corporations feel their interests are threatened. As authoritative reports attest, many of these individuals have been murdered. The organization Global Witness, for example, has documented that about 2/3 of those murdered annually are Indigenous and environmental rights defenders. One of numerous examples is Berta Casares, a Lenca Indigenous woman, co-founder and coordinator of the Council of Popular and Indigenous Organizations of Honduras, an environmental and Indigenous rights advocate. She was assassinated in 2016. The problem of attacks and criminalization of Indigenous rights defenders is now central in international human rights work and has been described as a global crisis. In 2018, it was the subject of a seminal study presented to the UN General Assembly by the Special Rapporteur on the Rights of Indigenous Peoples. The study pointed out that some of the strategies employed are threats and intimidation, social smearing campaigns, character assassination, travel bans, and insidious harassment in the form of criminal charges, which are often nebulous, grossly inflated, or fictitious. It's regrettable for our societies that various corporations, with their virtually unlimited financial resources and legal teams, choose to overwhelm public systems and processes of the judiciary in order to disempower those who defend the most marginalized and disempowered, as many Indigenous peoples' communities often are. As we see, in other words, the courts then are playing fields today where Indigenous peoples' rights can be upheld or not, where Indigenous rights defenders can be protected or not. Some questions for our panel: what are challenges of finding justice for Indigenous peoples' rights in courts? What are the risks of such efforts? What are the results of strategic litigation? What are achievements we can see through the courts? What is the potential of courts in the legal, historical, political, and social spheres? So with us today to explore these very complex issues are three lawyers, three eminent colleagues, Carla Fredericks, Stephen Donziger, and Manaka Infante. I will introduce each one before they speak, and I will now start with Carla Fredericks. Carla Fredericks is an enrolled citizen of the Mandan, Hidatsa, and Arikara Nation of North Dakota. She is the Chief Executive Officer of the Christensen Fund and is a seasoned leader in sustainable economic development, human rights, business and finance, Indigenous peoples' law, and federal Indian law. Her core work has focused on the realization of Indigenous peoples' human rights. She has served in several capacities, including providing support to the UN Special Rapporteur on the rights of Indigenous peoples for the entirety of her 2 terms, serving as counsel to the Standing Rock Sioux tribe in bringing their opposition to the Dakota Access Pipeline to international fora and financial institutions, assisting the Maya peoples of southern Belize in implementing the affirmation of their land rights and developing a model for Indigenous-driven consent processes and remedy. Carla Fredericks is a graduate of the University of Colorado and of Columbia Law School. She is a member of the Indigenous Peoples Advisory Group on the Decolonizing Wealth Project. As a faculty member of the University of Colorado Law School, when she was there, Carla reconstituted First Peoples Worldwide in 2017 as an interdisciplinary cross-campus program that engages Indigenous peoples, investors, companies, financial institutions, and policymakers to promote implementation of the Declaration on the Rights of Indigenous Peoples. She has deep experience as an expert and innovator in the fields of finance and human rights. And with First Peoples Worldwide, she created a model for a private equity fund that supports sustainable resource development and entrepreneurship in Indian country, supporting, among others, the Wichin people in protecting their lifeways from extractive industry development in the Arctic. Through her long affiliation with the Investors and Indigenous Peoples Working Group, Carla has advocated full integration of human rights into the capital markets and facilitated improvements to environmental and social risk management frameworks, including the Equator Principles. In 2020, she led the organizing of investors that helped to achieve the Washington football team name change. She's also a prolific writer. She also is a litigator who has worked with Milberg LLP in New York and established their Native American Indian law section. And of course, when she was at Colorado Law, she held an amazing American Indian law clinic preparing students for their complex involvement in this field. So Carla Fredericks, the floor is yours. Thank you for being with us today.
Oh, thank you so much, Elsa, for that very kind introduction. I honestly can say that I never really thought when I was attending Columbia Law School that I would be here participating in a webinar like this at Columbia. My interests at Columbia were really around litigation and maybe financial services litigation. And as a tribal member, I really was pulled back by my own community into representing tribes and really bringing their concerns before the court. I started really, as you said, working in financial matters and building a practice around that. But as I'm going to talk about today, pretty much any case that implicates an Indian tribe in the courts goes back to the treaties. And I quickly learned when I engaged in this practice on behalf of tribes that if you were talking about something, a legal matter, going back 200-300 years was not uncommon to really understand the record. So I'm going to talk a little bit today about the importance of treaties for Native people. Yesterday, as you said, of course, was Indigenous Peoples Day. And there is a great opposition throughout Indian country to Columbus Day as a national holiday. And the Biden administration on Friday actually issued twin proclamations recognizing both Indigenous Peoples Day and Columbus Day in the United States of America. And that's the Indigenous Peoples Proclamation is the first such proclamation by an American president recognizing this day as a national day of recognition. So here we are in the United States, it's 2021, and the UN Declaration on the Rights of Indigenous Peoples has been affirmed by the United States by President Obama back in 2010. And I really reflected today thinking about this talk about where we are vis-a-vis the promises of the Declaration and how treaties with the United States for Indian tribes really represent their self-determination and honoring that self-determination as a matter of nationhood and of a contract, a binding contract with two nations. So there are, this panel is too short to really go into what amounts to probably 2 full courses on federal Indian law and treaty rights of tribes, but it's to oversimplify a great deal. There is a recognition in the United States jurisprudence that the treaties with the Indian tribes are a body of law that the courts must rely upon. And I say it that way because our United States Constitution, of course, recognizes treaties as, quote, the supreme law of the land, which is known as the Supremacy Clause of the US Constitution. But the Indian treaties have shown themselves by the courts to not rise to that level of supremacy. And in fact, because of several US Supreme Court decisions have actually been subsumed by congressional power, which is known as the plenary power doctrine. So the basic lay of the land vis-a-vis the courts and Indian tribes is that the United States in the treaty and intercourse period prior to the nationhood of this country engaged, and after actually the inception of the United States of America, engaged in treaty making with the tribes. And this practice really put forth the full faith and credit of the United States government in agreements which represented consideration to the tribes for cessation of land rights. And these treaties, as everyone probably knows, have not been upheld as a legal matter. And there are several court decisions that through all sorts of interesting contortions indicate why these treaties could not be upheld as provided for in our United States Constitution. That being said, there have been some really incredible victories, starting in 1832, when John Marshall laid down Cherokee, that one of the Cherokee Indian cases, Worcester versus Georgia, which actually struck down Georgia laws that purported to seize Cherokee lands on which gold had been found. And Justice Marshall found that seizure of land by the state of Georgia actually violated federal treaties. Now, one interesting thing to mention, and the other panelists can really talk more about this in the international context, is the statement of Andrew Jackson at the time that decision was handed down, which is quite famous, where he said, John Marshall has made his decision, now let him enforce it. So it's one thing for the courts to go ahead and actually apply the treaties as the supreme law of the land, but there are enforcement issues, which I know we're going to talk about later. The other matter that probably is a little bit more contemporary in the minds of our audience is the Dakota Access Pipeline, which is a case that I worked on behalf of the tribe. My role was to bring the concerns of the tribe to international fora and also to engage with the financial institutions that were funding the pipeline, which was work that was a companion to the litigation that was going on in the United States courts. And what I can share about the litigation in the US courts is that really what the tribe wanted was actually to have their international human rights respected. And they used the United States courts and the mechanisms that were available to them under US law to actually try to ensure that their free, prior, and informed consent, as guaranteed in the UN Declaration on the Rights of Indigenous Peoples, was in fact respected. And so what you see in that case is a whole bunch of domestic legal machinations around the National Historic Preservation Act, the National Environmental Policy Act, and then also the Sioux treaties, several of which were implicated in that case being brought to bear. But the key tenet of the case was always that the tribe did not feel that it had its free, prior, and informed consent respected or upheld whatsoever in the entire situation around the Dakota Access Pipeline. And for anyone who is unfamiliar, the basic plot of the case was that Energy Transfer Partners was a company that sought federal permitting from the United States to build a pipeline 1,500 feet from the tribe's reservation, Sandy Rock Sioux tribe's reservation boundary, at their water intake point underneath the Missouri River. And the tribe was deeply concerned about the treaty lands that were being encroached upon, as well as the environmental hazards that the pipeline project presented, and the devastation to the historical and funereal and human remains that were also in the pipeline path. And so the tribe engaged really on all fronts. And I think that's another key takeaway for this talk tonight, that these fights happen in the courts, but they also happen in policy forums, in public relations contexts, in international fora as well, that Indigenous peoples will fight to protect their rights in every available forum that they have. And the court case actually finally did proceed on the basis of the tribe's treaty claims, but by that point, the pipeline was already in the ground and operational. And so, as with many of these cases, what ended up happening was that it was really too little too late. That although the tribes from the very outset warned the court that injunctive relief was necessary to protect their rights, that the court didn't find that there was enough of a clear and present danger to the tribe at that time. And so the as the case proceeded, the pipeline continued to be built, and it wasn't until the harm was already done that that the courts got around to recognizing that there was, in fact, this grave harm that and injustice that the tribes experienced. And this too often, I think, and both of the panelists have experienced this, I know, this just too often is the state of play for Indigenous peoples, that injunctive relief is a very difficult hurdle in courts to be able to achieve. And then by the time that the court has made its declaration, the damage has been done. So I will say that, there is light at the end of the tunnel. I think that where we are now is that throughout the world, actually, there is more of a move toward respecting Indigenous people's rights as a matter of both international and domestic law. And you see domestic courts, and it's really through the pleadings and theory of the case of the litigants of the Indigenous peoples beginning to recognize Indigenous people's rights and beginning to understand that these issues are not statutory or constitutional, but really far beyond that, I would say, and universal. So thank you for letting me share the story of the Dakota Access Pipeline. It's a story that's very close to me. My own community, it's our oil in that pipeline. It's Bakken shale oil that comes out of my community. And the reason that that we're sitting on top of that oil is because we were actually relocated against our wishes. So all of these things have this kind of concentric flavor to them for Indigenous peoples as well. And I think that there is a deep recognition that we are all connected, and that we must all work to protect each other's rights for the survival of everyone. Thank you.
Thank you so much, Carla, for bringing all this out and for saying that actually we need to also join hands and protect each other. It is now my pleasure to introduce Stephen Donziger, whose bio can be found on a website called Americans Who Tell the Truth. Stephen Donziger is a Harvard Law School graduate and environmental lawyer. And he never imagined when he joined the legal team bringing suit against Chevron for devastating large parts of Ecuador's Amazon rainforest and affecting the health, livelihoods, and overall well-being of thousands. He never imagined that the case would take up a good portion of his life and define his career. Just 2 years out of Harvard Law School, when the class action suit began, Stephen Donziger has spent decades on the legal battle to bring justice to the Indigenous peoples of the Amazon. His clients are 5 Indigenous groups and dozens of rural communities in Ecuador's Amazon, 30,000 people, that Chevron has made the victims of an atrocious oil-related environmental and human rights disaster. Stephen Donziger has been subjected to personal attacks and attacks to his family by Chevron that defies a legal judgment that they pay compensation for their crimes in Ecuador's Amazon as proven in a court of law. Environmentalists nicknamed Lago Agrio, the area of Chevron's environmental devastation, as the Amazon Chernobyl. In 1993, Stephen Donziger traveled to Ecuador with a team of lawyers to investigate. They found what looked like an apocalyptic environmental disaster in the rainforest. Open waste pits throughout the rainforest, people drinking contaminated water, oil on roads, oil on people's feet. And Stephen Donziger has pointed out that this was not an accident like you saw in the Gulf with the BP accident. It was clearly foreseeable that this deliberate dumping of billions of gallons of toxic waste would not only destroy the environment, but it would kill people. Chevron refused to honor the Ecuadorian court's findings and requirement for compensation, and instead removed its assets from the country. The company then used 60 law firms and 2,000 lawyers to wage a full legal attack on Donziger and his clients. In the meantime, the people of Ecuador's Lago Agrio region continue to suffer as unlimited pits filled with crude oil and toxic waste continue to contaminate water and soil and destroy lives. The director of Amazon Watch, Paul Pazimiño, calls Lago Agrio a perfect example of environmental racism. Stephen Donziger has been vilified in the US legal system for his work in this case. In a recent opinion issued a couple of weeks ago, the UN Working Group on Arbitrary Detention, composed of 5 international jurists, concluded that Donziger's home detention for more than 2 years violates the International Covenant on Civil and Political Rights, to which the US is a party. The working group said that the appropriate remedy would be to accord Donziger an enforceable right to compensation. It is my pleasure to give the floor to Stephen Donziger.
Thank you, Elsa, for that lovely introduction. And Carla, Manaka, Maggie, it's an honor to share the floor with you. I'm going to talk really in 2 parts. First, I'm going to explain a little bit about what happened down in Ecuador, and then in the second part, I'm going to explain what Chevron is trying to do to me and what I think it means for Indigenous rights, Indigenous legal rights, both in the United States and around the world. You know, a lot of y'all might probably know the story down in Ecuador, but in a nutshell, and this is a 28-year story. And by the way, I've worked on a lot of other cases in this time, not just this case. And the other thing I want to say is I work as part of a team of lawyers. It's not my case, it's a case brought by communities in Ecuador, and I had the privilege of assisting these communities and still do. But essentially, I went down right out of law school, or shortly after I graduated from law school in 1993, to the northern part of Ecuador's Amazon. It's in its natural state, it's a beautiful area. We had been told by various sources that there was a big pollution problem caused by Texaco. We now say Chevron because Chevron, after the initial lawsuit was filed in the early 1990s, bought Texaco and is now the defending entity. But in any event, Texaco designed a system of oil extraction that was essentially designed to pollute the ancestral lands of various indigenous peoples that were living in this area, which is about a 1,500 square mile area. So as Elsa pointed out, unlike most oil problems you see around the world, which are as bad as they are, they're caused by negligence or recklessness or they're accidents. In Ecuador, this was part of a deliberate design to pollute. Essentially to offload oil waste that is a natural part of the drilling process, not dispose of it properly, and dump it into the lands, the rivers, the streams that the local communities had relied on for their drinking water, their bathing, and their fishing. And this happened in a systematic way over a period of 25 years, to the point where at the height of the operation, there were 4 million gallons a day of this toxic wastewater filled with benzene and other cancer-causing chemicals, scalding hot, that were being dumped into rivers and streams with absolutely zero warning by the company to the people who lived in the region. I mean, as an example, and I've heard this story directly from people who live there, you know, when Texaco first came down and started engaging in these horrific practices, people asked, what are you doing? I mean, we thought you were Texaco, you're an American company, you should know what you're doing. And the inevitable response was, no, there's no problem. Oil is like milk, it contains vitamins, it's perfectly fine to drink and to rub on your body. And this total lack of respect, this racism toward the people by the American oil company, really govern the entire approach to the operational practices. And unfortunately, I think governs the approach that we're now seeing in US courts toward this entire case. And on the legal side, what ended up happening is the people of Ecuador didn't trust their own court system. I mean, Texaco had operated and dumped with impunity for 25 years. They're like, we want to go to your country, where Texaco's headquarters is, where the executives made the decision to engage in these practices. and we want to sue there, which meant here in New York, where I live. I actually live about 10 blocks from Columbia University. I've lived here for 15 years. So the initial lawsuit was filed in the Southern District of New York here in Manhattan as a class action lawsuit, November of 1993. And Texaco at that time fought really hard for 10 years using very top level corporate law firms to get the case dismissed down to Ecuadorian courts, where the people who had been victimized had never even recovered $1 in tort damages over the, by then, 25, 30 years of this open air dumping into their lands. So they clearly wanted the case in Ecuador because they thought they could engineer a dismissal. We litigated that issue for 10 years, 1990s, went back and forth to the appellate court twice. And ultimately, Texaco, by then Chevron, it was Chevron because they bought Texaco, won that battle, and the case went back down to Ecuador, where they accepted jurisdiction after they had filed literally 14 sworn affidavits praising the integrity and transparency of Ecuador's courts. We then went down there. When I say we, the American lawyers who were involved, and this was a private funded plaintiff side class action. Okay, it was not, it was sort of set up as a typical plaintiff's case. And we ended up working with a series of fabulous Ecuadorian lawyers. And over an 8-year period from 2003 to 2011, we had a trial. And when I say 8 years, that might strike some people as like crazy, right? How does a trial last for 8 years? I mean, a trial. I don't mean trial plus appeals, just the trial. And Ecuador is a civil law system. The trial involved dozens of field inspections of contaminated sites, 64,000 chemical sampling results, 105 expert evidentiary reports were submitted by both sides. Chevron fought so hard to obstruct that trial every step of the way. Their defense against the indigenous groups was just to delay, sabotage. They knew the evidence was against them, and they knew if the case came to a conclusion, they would likely lose, which is exactly what happened in 2011. They did lose on a very significant pollution judgment. At that time, it was about $18 or $19 billion judgment between actual damages and punitive damages. It was later reduced by half on appeal. The Supreme Court of Ecuador got rid of the punitive component for various reasons related to Ecuadorian law. But in the end of the day, the communities ended up with a judgment in the amount of $9.5 billion, which, depending on how you calculate interest, has since gone up, not insignificantly, to maybe 11 or $12 billion, given the amount of time that has passed since the judgment was issued in 2011. At the time the judgment was issued, Chevron vowed publicly never to pay a penny. They had sold off all their assets in Ecuador to prevent collection. And they decided to adopt a strategy largely to demonize and criminalize the lawyers, primarily me. I was very visible during the lawsuit. I was speaking to the media. I was helping raise funds. I was sort of considered a spokesperson, along with other people. I was not the only one, but I had a high profile role. And they came back to New York, the very courts where the Ecuadorian indigenous peoples originally had come in the early 90s to file suit that was never good enough for Chevron or Texaco. And they came back to those same courts and sued me personally for the most amount of money that an individual in our country ever has been sued for, $60 billion, which is treble damages on the original roughly $20 billion judgment under the civil RICO statute in the United States. And their theory, and sort of this gets into the area like doctrinally of, when indigenous peoples have legal success, what are the tools these corporations can wield to block that success from being implemented? This law, which was passed by the US Congress to target the mafia 4 decades ago, was turned on its head and was used to portray our entire effort, that all the people who worked on our team, all the lawyers, the technical people, the scientists, as a conspiracy to extort money from Chevron Their theory was the entire litigation was a sham. But the problem was, of course, the scientific and other evidence behind the case, which, by the way, has been affirmed by 6 different appellate courts, 3 in Ecuador and 3 in Canada for enforcement purposes, including the Supreme Courts of both countries. But they still, under this crazy theory, went to this one US judge here in New York. His name is Lewis Kaplan. He's a former tobacco industry lawyer. And they sued me and all 47 named plaintiffs here in New York. Most of the plaintiffs did not exceed the jurisdiction, never came. I live here, I had to go. I was denied a jury. I'm the only person in US history ever to be denied a jury in a civil RICO case. Chevron presented a witness to whom they paid literally millions of dollars, an Ecuadorian man who came in and told a story about how he was in a meeting where I supposedly approved a bribe of a trial judge in Ecuador. Totally false, never happened. There's no evidence to back it up other than what he said. We found out later, he had been coached for 53 days by Chevron's lawyers prior to taking the stand. And a year later, he admitted he had lied repeatedly in this so-called trial. Again, this bench trial where Judge Kaplan found me guilty in a civil case of committing felony criminal offenses. Now, what really was this about? Okay, this was about a counterattack, a power play by Chevron and the fossil fuel industry writ large against indigenous rights. I mean, there's no other way to describe it. I'm not indigenous. I grew up relatively privileged, by the way, in the United States, went to Harvard Law School. I love this kind of litigation. I love human rights work. It's what I do. And they went after me personally, in my opinion, unlike I've ever seen a corporation or judges go after an American lawyer. And it's a form of retaliation. And as Elsa, in my view at least, as Elsa pointed out, the United Nations Working Group on Arbitrary Detention recently found that it was reprisal against me for the work I had been doing, or have been doing successfully in this case. And beyond that, things got really scary when post this RICO judgment, we kept, meaning our legal team kept enforcing the Ecuadorian judgment against Chevron's assets in other jurisdictions like Canada, where we had quite a bit of success. Chevron then went back to Judge Kaplan and asked for him to impose court costs on me, which were literally millions of dollars, which ended up essentially wiping out all my life savings. I live, by the way, with my wife and son, who you might have just seen in the background. He's 15. So my wife has an income and we have a legal defense fund, but I have been unable to make any money for over 2 years while I've been locked up in my home. And the way that went down is Judge Kaplan ordered me to turn over my computer and sell to Chevron with all this confidential privilege information. I was quite open and honest. I said, I can't do that. Please hold me in civil contempt, which would allow me a direct appeal on this civil discovery order. This is a little technical, but just bear with me here. It's very hard to appeal in the United States, these sort of interim orders about discovery from judges. The only way to do it is to disobey it openly, go into contempt, and then you can appeal it. And this is a very normal, well-trodden path for lawyers to take. It's happened throughout our history, and no one ever has been charged with criminal contempt for engaging in this practice, which is traditional lawyering, but me. So when Judge Kaplan found me in civil contempt, I went ahead and appealed his order. He then charged me with criminal contempt of court for appealing his order. I mean, for challenging the lawfulness of his order that was under appeal. And then he took the case to the US attorney in New York. The US attorney declined to prosecute me. I think because the US attorney knew this was not a legit case. Judge Kaplan did not stop. He appointed a private law firm in New York called Seward and Kissel to prosecute me directly. He did not disclose that Chevron had been a client as recently as a year before of this law firm. He then appointed a judge instead of going through the random case assignment process, and the Chevron law firm prosecutor asked for me to be locked up in my home as a risk of flight, which again was preposterous. It's just not how I roll, and I have a family here, and it's a misdemeanor case. And I've been here now for 799 days in my home with an ankle bracelet. Tomorrow's day 800. I was again denied a jury in my trial. Judge Preska, which is the judge who locked me up as a risk of flight, without a jury, found me guilty of these contempts. I believe I'm innocent. I believe there's no legal basis to look at any of this as criminal. And she sentenced me last Friday to 6 months in jail, which is the maximum sentence, on top of the 2 years, 3 months I've already been in house arrest, when the maximum sentence for a misdemeanor is 6 months, and the maximum sentence ever given a lawyer convicted of my level of offense is 90 days of home confinement. So it's sort of hard to believe, but that this is happening, and it's complicated, and I'm a relatively strong person, as is my family, and we're dealing with it. We have a lot of support, and being able to share the story makes me feel great tonight. I want people to know about this. But ultimately, it's extremely complicated on a personal level, and I think it is absolutely a reaction by US courts that are designed to intimidate Indigenous peoples and their defenders and earth defenders and water protectors from engaging in this kind of work at this kind of level of success that involves shifts of significant amounts of money of compensation for major pollution problems. And I think they're weaponizing me in this case to intimidate others into not doing this work out of fear that they too will be criminalized through these bizarre court processes. Now, I've not given up. 2 points I want to make before closing here. One is the people of Ecuador are not me. They have their case. They have other lawyers working on it. And the hope is that this judgment will be enforced at some point relatively soon in other jurisdictions. The second thing is the way my situation obviously is at least somewhat connected, but it doesn't completely overlap, because even if I have to go to prison, and I hope I won't because I'm appealing, but even if I have to, that case will, the bigger case will continue. But I do think that I relate to that in a very significant way, and I really need people to know about this and to spread the word and to help protect me and what I stand for, which is really the right to be a lawyer and to do it successfully on behalf of Indigenous peoples who are victimized by major polluters and companies that are really engaging in practices that are leading to the destruction of our planet. It's all connected. So that's sort of the story. I know it might be shocking to some, I don't know. It's certainly shocking to me and my family that we're living this ordeal. But, you know, we have no choice but to keep trying to fight through it. And we believe in the US legal system, at least to the degree that we hope the appellate court, where we have 2 appeals pending right now, will intervene and stop what we see as an abuse of the legal process by Chevron and 2 judges who are really engaged in a corporate criminal prosecution, the first of its kind that we've seen in the United States. One final point, sorry, I want to be clear about that. While we're suffering here, I want to recognize there are people in this world, Indigenous peoples, people of color, others who suffer from our criminal justice system a lot worse than we are currently. And I want to acknowledge that. I also want to say, though, that what this is something that I'm a pretty astute observer of our system. I've never quite seen this, direct corporate criminal prosecution of an individual, of a defender. And I think that this is a model, it's a playbook of sorts that the fossil fuel industry intends to use, and to some extent has already used, against other entities that engage in this work. And I think it's important to be aware of this playbook and to understand that if they get away with it to the extent they have with me, I think they plan to use it again against others who also do this work.
Thank you very much, Stephen, for underlining the crucial importance of the right to be a lawyer. And, today I was rereading this international guidelines on the role of lawyers. And there is so much there about the independence and the fact that they need to protect their clients and all this. I imagined for a moment, having worked at the UN for 31 years, if I were, let's say, one of these 5 members of the working group, UN working group on arbitrary detention, these international jurists, because I'm not a lawyer from the US, but from Greece, how this case would look to me. It would look to me like something like what the opinion expressed. I must say it's a shock, and we hope that this will not be upheld in this way, but that, as you mentioned at the end of your remarks, we trust in the legal system and in the good jurists that we find in the legal system, indeed. So I am proud of our profession. Mm-hmm. I would now like to turn to and to introduce to you Manaka Infante. Manaka Infante of the Baniva people is in the Amazonian region of Venezuela, is also a distinguished lawyer. She now works as the program officer at Open Society Foundation, where she leads the foundation's work on citizen security and justice in Latin America. Between 2010 and 2020, she worked with the United Nations in different roles. In New York, helping protect victims of sexual exploitation and abuse. In the First Verification Commission on Colombia, overseeing the laydown of weapons and the ceasefire agreement, coordinating complex investigations against organized crime at the International Commission Against Impunity in Guatemala, and as a citizen security, justice, and human rights advisor at the United Nations country team in Venezuela. Prior to that, from 2008 to 2010, Manaka practiced law as an attorney, litigating criminal law and human rights cases, including indigenous rights cases before national courts and international human rights mechanisms. She also completed a fellowship on indigenous rights in the office of the UN High Commissioner for Human Rights in Geneva. Manaka Infante earned her law degree summa cum laude from the Universidad de Carabobo in Venezuela, an LLM cum laude in international human rights law from the University of Notre Dame, where she was recipient of a Fulbright scholarship. She also holds a postgraduate degree in human rights from the Deusto University in Bilbao, Spain. Manaka is the kind of lawyer whose integrity and commitment to justice have led her to suffer threats and intimidation attempts to her person and her family. We were very honored to have her present at our university seminar on Indigenous Studies here at Columbia some years ago. Manaka, the floor is yours. Thank you for being with us.
And Elsa, it's an honor to be in this panel. So Anetua Jasapua is to say hi in my language, in the Baniva language. I currently work, as Elsa said, at the Open Society Foundations and previously worked with the United Nations and was an indigenous activist in my country. So I will refer to 3 experiences in working with and following the work, of course, on indigenous rights. First, as an indigenous rights defender in my home country, Venezuela. Second, as a UN legal coordinator for CSIL, for the International Commission Against Impunity in Guatemala. And third, as a UN liaison officer in Colombia, following the peace process there. So I have a mix of experiences in following the work of courts on indigenous rights. So in Venezuela, I supported and I work with several organizations, including APIVEN, Asociación de Pueblos Indígenas de Venezuela, at a time of great optimism. Venezuela had just approved a new constitution, among the most progressive constitutions in the world, recognizing us indigenous peoples and setting the stage for the development of laws to develop the specific rights of indigenous peoples. The optimism, however, soon turned to disappointment. Private and public companies routinely ignored these laws, the government not only turning a blind eye to this, but actively encouraging it by granting large mining concessions, gold, coltan, and other minerals on indigenous territories, without a free prior informed consent and consultation, and even issuing decrees that provided the armed forces authority to carry out everything that had to do with legal activities for petroleum, gas, and general mining services without any limitation. So courts, tribunals, the line of defense against this abuse largely abdicated this role by dismissing any challenges brought against these laws. What's worse is that somehow they became complicit in facilitating the usurpation of indigenous territories by facilitating persecution against indigenous leaders that challenged businesses. Such is the case of Yucpa chief Sabino Romero, who I represented as a lawyer, and I obtained measures for him from the UN Working Group on Arbitrary Detention that Elsa and Stephen mentioned, the same group that recently provided the opinion for Stephen's case. I think this was the first case of the UN Working Group addressing indigenous rights and considering the case of an indigenous leader that was some 10 years ago. So the Yucpa chief, Sabino Romero, had denounced the complicity between local government authorities and landowners against the indigenous of the Perija area and was imprisoned under false charges for this. In 2013, Sabino Romero was shot dead by what we consider likely were henchmen of a local rancher, and the real authors of this crime still free almost 10 years after his death. Switching now to Guatemala, I found in Guatemala a much more organized network of indigenous rights organizations willing to use the appropriate institutional mechanisms to claim their rights. Unlike in my home country, there were massive efforts by the UN to sensitize judges, prosecutors, and lawyers on indigenous people's rights, international norms and standards on this, and how this apply to Guatemala's laws. So well-reasoned, well-prepared, paradigmatic cases were often presented before national courts on everything from evictions, ancestral territories, access to education, media channels. There were deep discussions on how to link ordinary and customary law systems. Indigenous peoples obtained several legal victories in national courts, restituting indigenous lands to their rightful owners, ensuring adequate representation of indigenous peoples in local councils, dictating compensation measures for wrongly evicted indigenous families, ordering the granting of spaces in the electromagnetic spectrum for indigenous media. So you can mention in a case, there was perhaps the most famous case was the Pursarco military camp that resulted in the sentencing of 2 members of the military for the enslavement of indigenous women and the forced disappearance of their husbands. So each of those cases surpassed, of course, innumerable obstacles to achieve justice, from long and costly processes, from insufficient coverage of the ordinary law system in terms of both location and number of justice operators, victims, experts, and witnesses who didn't speak Spanish, the recognition of validity of proof based on customary norms. But not only that, plaintiff also had to struggle against justice operators with racist and discriminatory attitudes, discretion in the application of law, and lack of transparency in every step of the process. So these racist and discriminatory attitudes extended well beyond the courthouse. Indigenous plaintiffs were questioned over their authenticity as truly indigenous, accused of harming the country's image and interest for personal gain, instigated by foreigners to do so. So they were attacked regularly in public discourse as greedy enemies of society, bent on destroying the hard-won social cohesion achieved after the internal armed conflict. So far from serving as learning moments for Guatemala society to progress towards a more cohesive and just society. So cases were used by the country's elites to rehash old narratives as indigenous peoples being an obstacle to peace, to progress, and overcoming poverty. So what's worse, court decisions were only partially implemented. If implemented, for me, it's hard to listen from Carla and Steven that the main problems are implementation and reprisals, because it's the same in the countries I have seen and I have worked on. So convictions in Guatemala never reached the higher echelons of power responsible for the greatest crime. Rios Mon, for example, who presided the government responsible for Sepulsarco, died in 2018, and he spent last that weekend in jail. So working closely with the Attorney General's office in bringing other high-profile cases before courts with CSIL and my role as a legal coordinator in CSIL, I could see some of the reasons behind this. Threats against justice operators by big interests, chronic and purposeful underfunding of the justice system, informal networks of privilege and patronage, corruption. So with the CSIL, we were able to bring some of the culprits behind some of these practices to light. But a key lesson from this period was the need to see courts' role in promoting indigenous rights holistically. And presenting a case before a court is by no means all that needs to be done. So these lessons that are learned in Venezuela and Colombia served me when I was put in charge of verifying the Colombian peace accord in a locality at the interior of Colombia with a significant indigenous population. So once again, I saw the optimism raised in indigenous peoples by a new legal framework, in this case, the peace accords that included a whole ethnic chapter devoted to ethnic and indigenous rights. And once again, I saw how violence and big business interests from forced to bring about greater recognition of indigenous rights. So Colombia has a sophisticated judiciary with an already standing record of challenging the executive and the legislative laws when these don't stand up to the review. Back in 2016, 2017, when I was in this role, the peace accord were the expression of the highest political will to implement changes, and plus the sophisticated judiciary and a strong and vibrant indigenous movement. You may think, well, this is the time to see changes happen. However, after several years, when we see the situation, very little has been implemented with regards to the Ethnic Chapter, and courts remain having a key role. So I would say, to conclude, I see a clear opportunity and a need to push courts to exercise their role in advancing the recognition of indigenous peoples. And I think in Latin America, in my region, the moment is clearly now. There is a clear questioning by broader society of the prevailing social contract. Mass protests in Chile, Colombia, and elsewhere have shown this, and elites are on warning that their privilege are being questioned. So things will have to change, I think, and courts being only one of the proper institutional avenues for these changes to happen. However, we should not be naive and think that strategic litigation will bring about the deep structural changes that exist because of stronger power imbalances in our societies. But we need to engage more society. I think indigenous rights shouldn't be only an issue that is spoken only in indigenous friends circles. We need to engage more society, the broader society, and make these legal victories that we have into real learning moments for the society. So I think that working with courts, we can see that there is such a thing as a corrupt judge or judicial official, but many justice operators are as much victims of inequality and injustice as the victims are. And I will say, finally, winning a case does not equal to achieving one's goal. It's only a partial victory, even and sometimes an insignificant one. if we cannot continue the pressure, and as I said, engaging society as a role, but also taking into advantage this moment to show the value that Indigenous peoples bring to society. So thank you, Elsa. I'm happy to continue with questions.
Thank you so much, Manaka. And you brought together, the courts into various policy issues, into peace processes, because courts are not in a vacuum, as you say. I mean, it's not just the court. The court is in society and in politics. So, okay, so all of you have brought such a broad span of issues on our topic, and you have also pointed out on some common points. I invite you to take a look at the questions that are brought by our audience. And I would like now to have a follow-up question to each one of you, trying also to absorb some of the questions that come from the audience. And please also look at them as well. And in these questions that I address to each one of you, maybe also the others can jump in if you would like to do so. So to Carla Fredericks. So Carla, based on your vast experience with courts and private corporations on the topic of Indigenous people's rights, in what specific industries do you see the biggest challenges? And what are the risks for Indigenous people's rights of taking cases to courts, especially the US Supreme Court? And what about the issue of implementation of court decisions that affect Indigenous peoples? You mentioned the word implementation, but if you can speak a little more about it. Thank you.
Sure. I mean, it's a complicated question with a lot of different parts. So I'll start with the first one. The first one is really what industries really represent the most risk for Indigenous peoples. And I would say that probably the number one reason for oppression of Indigenous peoples is resources. And that's the whole backbone of colonial practice, is the colonizers want the resources. And whether that resource is oil or timber or gold or water or, just fulfilling the energy needs and consumption for the rest of the world, that is the threat. And Indigenous peoples, because they have protected their territories from development against all odds for a very long time, are sitting on top of a tremendous amount of resources that the world needs. We're counting down now to the Council on Parties meetings, the climate change meetings that are happening in Scotland next month. They actually start at the end of this month. And one of the conversations that I think is really emerging is that Indigenous peoples should not be carrying the weight of how to reverse climate change for the rest of the world. We have the Sustainable Development Agenda, which is also proceeding the Sustainable Development Goals, particularly Goal 4, which is access to clean energy for all, without a mention of how human rights of Indigenous people are going to be protected. Many of you may not know that all of the electronics in your cell phone have to be mined to make the magic happen of your phone. And the mining of those electronics and the resources necessary to make the electronics, much of it is on or near Indigenous territories. And so that's one example. The other really emerging example is how we're going to transition into a green energy future and all of the minerals that are needed for solar. A solar panel needs a lot of nickel to be able to become a solar panel and create energy and harness the energy from the sun. There's a lot of nickel resources on Indigenous territories. And if we're not careful, I think that, once again, the needs of the broader population are going to trample on Indigenous people's rights, and the courts are going to let it happen, because you always see this kind of interesting balancing test in democratic societies, which is not protecting the rights of the few, and instead really protecting the interests of the many. And I think that's of grave concern to Indigenous peoples while our world is in this incredible crisis. And what my hope is that the courts will understand that the past practice of trampling on Indigenous people's rights is what got us to where we are now. It's not the solution that's going to get us out of here. It's actually the problematic exercise that got us here to begin with. So the second part of your question is really the question of implementation, and the question of where implementation can really take root, and how the courts can really engage with that question. Different jurisdictions have different outcomes on this, and where you really see success is where the courts are willing to take on an ongoing process of monitoring implementation. And I was really struck by Stephen's story, because it's interesting that the courts would be so incredibly heavy-handed to quash litigation and to quash people fighting for their rights, when they tend to turn a blind eye once they've made a decision to actually trying to get it implemented. And one thing that was very encouraging is when we worked on the land rights of the Maya people of southern Belize. Those land rights were, of course, confirmed by the Caribbean Court of Justice, applying the principles of the Declaration, and actually the Constitution of Belize itself, that submitted itself to the jurisdiction of the CCJ. But where the victory really happened is when Belize itself did not implement the decision and continued to encroach on the Maya people's land rights. And the Maya people went back to court in the CCJ, and the court assumed jurisdiction to be able to say, no, you actually have to implement the decision that we made, and these are the processes that we're going to set forth to ensure that happens. And so, we've seen this in other cases in the United States too, like the whole desegregation of schools after the Brown versus the Board of Education, and different ways that the federal courts endeavored to ensure that that desegregation did in fact happen. So if the courts can take such a heavy hand as they have in our brother Stephen's matter, they certainly can assert their jurisdictional powers to implement their own decision making for Indigenous people's rights. And I think we'll see more of that. Otherwise, as you said, Elsa, this is the foundation of democracy. And if our judicial decisions are not respected and implemented, then they're not really worth very much, are they? So it's quite important to the democratic fabric that we be able to go into court, to be able to access justice, to not be criminalized for accessing justice, and then to have, once justice is served, to actually have justice be served, as opposed to it be effectively meaningless.
Thank you so much, Carla. There is a follow-up question to Stephen that is linked to also to what you were saying. Stephen, you have seen, to say the least, a lot of these, or a lot of these cases, or a huge case, and you have seen that some decisions of courts have been positive and some have been negative. So my question to you is, given the enormous power of major extractive corporations, what types of action in law or policy or public advocacy do you think can impact positively on the courts? Or how can the courts be sensitized to human rights, to indigenous and environmental rights? I would like to hear your reflection on this, if you don't mind.
Thank you, Elson. Thank you, Carla and Manaka. Again, I feel kind of, I've worked so much on this one thing, and I think y'all have a much broader perspective on some of these issues. But, to answer your question, I'm sort of I try to be as realistic as I can about power dynamics. And I really believe the way to sensitize judges and other sectors in our society, I'm an American, so like I think of the US Congress or the US federal judiciary, is really to organize people around the principles that we all hold dear, around justice and around, living in a more fair society with less income inequality, and where indigenous rights can be respected and recognized after 200 years of treaty violations and other problems. Just the whole residential schools issue causes so much pain, and it's never been dealt with in our country, although it's starting to happen a little bit. And I think that's all a function of the work a lot of people are doing. And, but we have to recognize that the forces out there that, Carla mentioned the resource issue. I mean, it's such a driver of so many of these conflicts, and the resource extractors have so much power and so much money. And in my view, and because I've worked on this for 28 years, this one case, and it started, think about this, in New York federal court in 1993, and I'm still in New York federal court in 2021. And my personal view is it's just totally changed in those 28 years, from a court that I think was much more open to claims from human rights victims and indigenous peoples abroad who would have a problem with a US company, to a court that is now very hostile to those claims. And that is a function of how political power has played out in our society, in particular, appointments of federal judges, with the influence of the Federalist Society and what have you. Now, I don't want to get overly political in this panel, but I just want to point out that in my view, the answer to your question is we need to organize, we need to create alliances between different sectors so we understand the connectivity between all of these issues involving justice, and understand also, I would say, the primacy of the indigenous issue, for the obvious reason that, all of us who are not indigenous, who live in this land, are we either colonize it, or we're the successors to the colonizers. And there's a primacy to that issue that I think needs to be recognized, but also the connectivity to all the other issues of justice. And, those dynamics have played out in ways both positive and negative in this case I'm working on. I mean, let me be clear. Don't look at me and say, oh my God, that case failed. It did not. The case was successful. The attacks on me, to me, are a sign of the success of the people of Ecuador and what they've accomplished with help of a lot of people around the world, me among them. And that's what I want people to take away from this. Okay, it's my situation, as bizarre as it is, I don't think is representative of what usually happens in these cases. Okay, it's just this weird confluence of circumstances happening here in New York, to me, which ultimately I believe we will emerge from in a positive way. But I think overall there's been some incredibly positive developments through this case. There's been incredible examples set, and I would say inspirational examples of leadership and legal thinking and brief writing and advancement of various aspects of laws that only get, advanced through the practice of them. Like, you've got to bring them into courts and try to make them happen. And it's been fun, and it's been important and it's been significant. But it's complicated, right? And I think ultimately, whether the positive wins out, or sort of the resource extractive side wins out, is yet to be. No one knows the answer to that, but we can't afford as a people to sit and wait and see what happens. We have to make it happen. Otherwise, we're not going to have a planet to live on. And, you know, and the leaders of that movement, to me, have to be the indigenous frontline defenders of the earth. And, you know, we have to recognize the primacy, the important role that they play, and the important role of indigenous rights in this whole interplay of these different things happening.
Stephen, thank you very much for using this word connectivity. Understand the connectivity. And, you know, of course, tonight's panel puts the limelight, puts the courts in the limelight, right? So it's like we expect everything from the court, so to speak. But of course it can't be, you know. And what you were saying makes me think that perhaps we need, like we were dreaming in some circles at one point, we need also to sensitize the judges to indigenous people's rights, because we can't expect the judge, you know, to be the polymath or the person that will know everything and be sensitive to everything. We have to make it happen, you know, the advocates and the experts in this area. So I think we have our work cut out for us in this field, you know, of working with the judiciary of this country and of all countries, you know, to sensitize them to indigenous people's rights. What does it mean, you know?
But I'm going to give you a real quick example. If we had walked into court in the United States and someone like Carla was on the bench in New York, and Carla, I have no idea if you ever aspire to be a judge. I suspect you'd make a great judge, okay? But you don't see the faces of people who've experienced the problem, you know, so you're always battling this communication gap where just to get to square one and to explain the nature of the problem that feels so alien to many of these judges who haven't had that life experience. We need more diversity on our bench, in addition to sensitizing the existing judges.
Okay. Thank you. It's a big study in the making as we speak, I think, that we are having. Manaka, I want to turn to you and looking at various questions that were raised. You have this huge experience on indigenous people's rights and the courts in several countries in Latin America. You have also seen criminal courts used in certain ways to unveil crimes against indigenous peoples. And you have also experienced, you have thought a lot about strategic litigation. So I would like to ask you, do you think that the courts can be used successfully to educate society? I think Stephen also and Carla were speaking about this issue of educating society, or to provide some form of restorative justice for indigenous peoples. Could they do that? Can you comment on that? Thank you.
Sure. So I think the second part, the issue of restorative justice, deserves a separate mention. So it's hard to define what is exactly, what it means to victims and the communities that have suffered the abuses. Even some of the perpetrators are often victims themselves. So only they can decide if the restorative justice has been achieved. And this is on a case-by-case basis mostly. But this should not prevent us from seeking this. It's a right. So it should not prevent us from stating clearly how justice is also of benefit of the broader societies that surround us, including older generations that left without seeing their dreams of justice accomplished. And future generations which will learn from the present. So coming back to the first part of the question, on I totally agree. Courts should have a role on educating society. However, I think we need to look at the issue, but more holistically. If you ask me as a lawyer, I will say yes. If you ask me as an indigenous person, I will say so, right? Because if Stephen in New York had these consequences, can you imagine for Latin America how the cases are, or what the threats are for indigenous peoples? And I have seen this in most countries where I have been. So I think the role, of course, in strategic litigation, we need to look at this at broader lens, taking into account communication efforts, protection efforts for judges, for indigenous leaders, for lawyers. And this strategic outreach to broader society, I think, is key. You mentioned it, sensitizing judges. Yes, totally needed, but how we sensitize the broader society, how we engage them in connecting with our issues. So I saw that unlike my home country, I saw in Guatemala, massive efforts to sensitize judges. Did it make a difference? Somehow, yes, but we need to do more. So thank you again, Elsa, for the question.
Thank you, my colleagues. I see we have 4 more minutes, and I would like to recognize, I see a question from Japan, Professor Akihiko Morita, who was with us at Columbia University at some point for a year, and we were very happy for that. So what he's asking, he's bringing together the work of the Committee on the Rights of the Child that said in a recent, let me read this, in a recent statement, the Committee on the Rights of the Child admitted that each state has duties to address climate harm outside its own territory, and therefore can be held responsible for the negative impact of its carbon emissions on the rights of children within and outside its territory. How do you think this decision could and should affect national courts cases? This is, bringing the connectivity between the international and the national. Could this be used in litigation in national courts? Let's say if we imagine, a very big extractive that has done huge harm in a country. This is so common, like we heard in the case of Ecuador. Of course, this is climate change related, but you can say that climate and environment are linked like that. How could we use, such an opinion to go to the courts and take another state to the court, or on its own territory? For example, let's suppose it's a Canadian corporation. Can we go to a Canadian court to litigate on that? What do you think? Who would like to take this?
I think the more effective route is really figuring out where there are pressure points from some of these international bodies and their decisions, because if I believe that all of this is about resources, then I also believe that all of it is about the behavior of companies who are extracting resources. And you could, I suppose, take a country to court to try to get the companies to behave differently. But by the time you get there, Stephen's example, 1993, to now, the damage has been done, as I said, in the case of the Dakota Access Pipeline. We have had some success in bringing to companies, these different international decisions to say, you as a company have made certain commitments to abide by the decisions of these global policymakers. And in the following ways, you're actually out of sync with your own stated policies, which for companies is not just embarrassing, it's actually a huge corporate governance failure. And then shareholders start to get really upset because it puts their assets at risk, the money that the shareholders have invested in companies. And it's not shareholders like you or me, it's shareholders like New York State Common Retirement Fund, who have a lot of skin in the game, and they don't like it when a company is not adhering to its own policies. And then New York State and other concerned investors, Goldman Sachs, Citibank, they can have a dialogue with the company to say, you need to align your policies with this decision of this international body. And that's been very successful. It's actually how we got the Washington team to change its name. And I just want to kind of pull back to that point about narrative. The whole reason that we engage with that Washington team issue is not because of cancel culture or anything like that. It's because the United States Supreme Court sits in Washington, D.C. And the United States Supreme Court justices are driving by that stadium every day. And that's what they begin to think and understand about Native people. And so that's why that became a very important issue, is there is this other broad sweep of societal change and narrative change that has to go along with pressuring the courts and other policymakers.
Thank you, Carla. Anybody else? Your closing 2 sentences, I think it's actually talking about, it's the court in society and changing that narrative. This is so crucial. I would like to ask our panelists if they would like to make any other closing comment, because our time is up. Manaka, Stephen.
The only thing I'll say, since I'm the one with the most complicated situation, is if you want to learn more about our case or help with the defense fund, go to our website. It's freedonziger.com. It's not a pitch for money, I swear, but freedonziger.com if you want to learn more. Thank you, Elsa. This has been lovely. Appreciate it.
Thank you, everybody. Each of our panelists, and I cannot stop but saying one last sentence, because when we talk a lot about corporations, and we focus and we have the business and human rights guidelines of the UN and the Working Group on Business and Human Rights and so on, and we do all this work, we must never forget, when we are talking about human rights, that the primary responsibility for human rights lies with the state. In other words, the state has the international responsibility and is accountable for controlling companies that are on its territory or have their legal base on its territory. So I want to finish with that, because we should never forget that we have to hold, governments accountable, not just the corporations. So I would like to thank you, my dear panelists, my dear friends, and all the participants for being here, and for Maggie being with us, although she has a five-month-old, and she was accompanying us in this important event that marked the 2nd Indigenous Peoples Day at Columbia University. Thank you very much, and we have a lot of work to do. Thank you. Bye-bye.